Just a quick recap of what we've discussed in the last two webinars. In the immediate webinar before this one, we went into the succession laws of India, the origin and the history. We talked about the Dayabhaga school, the Mitakshara school, and how these two schools of Hindu law of thought were then merged into the Indian Succession Act, which is your primary governing law for succession and inheritance in India, and how it extends to not just Hindus, but also Muslims, Parsis, and Christians, and how Hindus, when we talk about Hindus, we also include the different sects, which is Jain, Sikhs, and Buddhists. We also talked about the difference between ancestral and self-acquired property, and how self-acquired property is property that you create through your own efforts. It's also your share in ancestral property, which has been properly partitioned. Your share from that is also considered to be self-acquired property, and how you are free to will your self-acquired property to whoever you like, while keeping in mind the legal obligations that you have towards your minor children, a dependent mother, or a dependent wife. And even for a woman, she also has to keep in mind the dependencies that she has on herself. Could be a dependent spouse or dependent children. We also talked about what happens if you do not create a will, how the Indian Succession Act has default schedules that come into play if you're a Hindu, when read along with the Hindu Succession Act, which then kick in and apply, and how your legal heirs become, basically get the right to equally own the property, and the problems with actually just relying on the default schedules and not creating a will or a trust, and how that creates difficulties. We shared stories around that. And we also talked about your rights and obligations vis-a-vis your property and your family. Before that, we had gone into, in the first webinar, we had talked about wills broadly as a concept, trusts broadly as a concept, and we had also touched upon real life stories that have come to our attention through our practice in this area, and where people have struggled for years on end because there was no will and trust. We also had a lot of questions that were discussed in the last two webinars. We will be doing a short response to an FAQ section with which the Hum Fauji team will share with you. And we'd be happy to continue engaging with you through your journey of, protecting your wealth and your family through a will and trust. So with this, we will dive into the discussion today, which is primarily around trusts. To begin with, I'd like to...
Just 1 minute, Pritika. I would like to speak for just about 2 minutes.
Please, yes, sir.
Yeah. So before we start the main webinar of today, which is a very, very important one, so please take as many notes as you want. The kind of things that the presenters would tell you, you may not find it through AI, through Google, and things like that. And most of you would be hearing about trusts, practical trusts, maybe for the first time in your life. In the last webinar, we had people appreciated that there was an extended question and answer session. So on that popular demand, today we will have a very long 1 hour of question and answer sessions. What I noticed last time was that some of the people, they started leaving the moment question and answer session started. I would say very, very, with all my sincerity, that there's a huge amount of learning in the Q&A session. I would say almost 50% of the webinar learning, and most importantly, the actionable points will come to you from the Q&A session, because these are your questions. So whatever you faced or whatever you visualize yourself, some of you visualize, that is being answered here. As far as questions are concerned, you can keep posting your questions right from now onwards as they come to your mind. They will be taken up in the Q&A session strictly on first come, first served basis. One type of questions that we will not take are those which are absolutely personal questions and may not pertain to people at large. For that, the presenters, they will give you free 30-minute window. They will give you a link. You can calendar link. You can book a slot there, and you can have a free 30-minute session with very very with the lawyers who've been doing this all their life. And the last one, at the end, how to go ahead and how we at Hum Fauji will make it easier for you to get into wills, trusts, or any kind of succession planning tools. We will be covering it at the end. Thank you very much. And Pritika, please carry on.
Thank you, sir. So with that, moving into the kinds of trusts that we see that are prevalent in India, primarily there are two kind of trusts. There are private trusts and there are public trusts. We see that public trusts are charitable in nature. We do not have a central law in place that applies to public charitable trusts. There are a few state-specific legislations like we see in Maharashtra, which require the registration of a charitable trusts. And typically families and individuals create charitable trusts for public interest purposes. We also see some families create such trusts. But what is of importance to us today is a private trust, which is covered under a central legislation which is called the Indian Trust Act, and this governs all kinds of private trusts. So this particular trust, this kind of a trust can also be used by a family and is being used by families to create trust structures to protect their wealth and to protect their family members, vulnerable or not. This is the kind of trust structure that is used for worst case scenario planning by families, also by businesses, also by family businesses. So this is going to be our core focus on today's webinar. And we will now quickly move into the next slide, where Bambi is going to discuss the nature of private trusts.
Thanks, Pritika. So when we talk about private family trusts or private family business trusts, broadly, the way to structure these trusts, you're free to do it how you want. But broadly, how we generally structure these trusts in accordance with the income tax laws also is as follows. So there is the concept of a revocable trust and an irrevocable trust, first of all. Now, in simple terms, basically, this means that, so if you all recall our first webinar, we had taken you through the participants of a private family trust. So there is the authors of the trust, then there is the trustees, and then there are the beneficiaries, right? So if you all recall, the authors of the trust are the people who actually own the properties, and who want to put these properties into the trust, right, for the benefit of the beneficiaries. So now there are two ways to do this. There is revocable and irrevocable. This basically means, when we say revocable, we basically mean that the authors of the trust, that is the people who own those assets and are wishing to put it into the trust, it means that under the trust deed they basically retain the expressed right to be able to terminate the trust or revoke the trust in the future as and when they wish to do so. In simple terms, this means that today they may decide to, take all of their properties and put it into the trust, and the trust, starts to function. But there will be a clause in the trust deed where they have expressly retained their rights, saying that, tomorrow in the future, we will still have the right to terminate this trust. And that would mean that all of these trust properties will come back to us. So in simple terms, that is what a revocable trust means. An irrevocable trust, on the other hand, is the opposite of that. It means that the authors do not retain any such, expressed right under the trust deed, wherein they say that tomorrow we can choose to terminate this trust deed and all of our assets will revert back to us. So that is the simple understanding between revocable and irrevocable. Now, the other patterns that we see, under a trust deed is with respect to how the trustees will, manage the trust properties and disburse the funds or the income from the trust property to the beneficiaries. Now, broadly, there are three ways to do this. There is discretionary trust, there is determinate trust, and then there is a hybrid version of both discretionary and determinate. Now, again, in simple terms, this basically means that in the trust deed document, it's basically decided. So, if we say it's a discretionary trust, it means that the trustees have the power to decide, how and when the funds will be disbursed to the beneficiaries, or the beneficiaries can, as and when they require, put in a request to the trustees saying that they require, funds for whatever reasons. In simple terms, there is no fixed distribution mechanism of fixed amounts that are provided in the trust deed, which is why it's called discretionary. Determinate, on the other hand, or also called a specific trust, is where from the get-go in the trust deed, it is decided, how the beneficiaries will get their funds and what the funds will look like. There can be specified amounts. So it can be a fixed amount or there can be a fixed percentage of the value of the assets. But the point is that there is it's known from the get-go as to how much or what amounts each beneficiary will receive. That is clear from the get-go. Hybrid, of course, it's understood is a mixture of both discretionary determinate. So there may be certain situations or for certain reasons where the trustees can decide, what the amounts will be and how it will be dispersed. And there could be certain, amounts that are already fixed for certain reasons, and those will, go out to the beneficiaries in a fixed amount. So that is the main, difference between these different patterns. Pritika, would you like to add anything to it?
I'd like to take them straight into the structure and then help everyone reflect on the nature. So this is really the broad structure of a trust. And this is where we apply the principles that Bambi has just discussed, and we will repeat those principles so that you develop a deeper understanding. So when you look at any declaration of a trust, or what some people also call a trust deed or a family trust, different names that are used for the same document actually, then you have, as you can see, you have the authors of the trust. This can be a single author or this can be multiple authors who are going to choose what trust property, as you can see in the middle, what trust property they are going to create a trust over for their beneficiaries. Now, actually, the authors can decide to make anyone a beneficiary. But today we are talking about a family trust. So the assumption would be that we are going to be choosing family members who are our relatives to become part of the family trust. But you can generally note that the beneficiaries can be anyone. But there are benefits for choosing your own relatives because there are certain tax benefits that come in when you create a pure play family trust. So in the story of trust, you have your authors who basically could be like the grandparents or the parents who decide, okay, we have a bunch of trust properties. We have our children and our siblings or our parents. and who we want should be the beneficiaries of our trust property. We have children today who are minor, under 18, and they may need help in case we are not around in the world. So let's put the property into the trust. We have siblings or parents who are dependent on us, and if something is to happen to us or if we become incapacitated, they need care and protection. So we need to build a system for them, so that if we are not able to personally manage, then the system will manage their well-being for them and for us. So let's move in these trust properties into a trust, into the family trust, which is basically that document that gets drafted and registered with the registrar. And let's appoint a few trustees. As you can see, there's also a trustee in this picture. And these trustees will forever follow the instructions that we have laid down in the trust document, and will follow the instructions we've laid down. We may give them certain discretionary powers like Bambi discussed if we trust them enough, or we may just make this like a determinate trust where they will have to follow the mandate we give them in the trust document. And they will manage this trust property for the benefit of the beneficiaries. The authors of the trust also decide if there are minor children, they should also decide who would be the guardian of these minor children after they're gone, or if they are not in a position to take care of these children. The authors should also decide who the guardian should be or how the guardian should be appointed for even adult members who have a disability or who may develop a disability. They should also actually decide who will look after their own selves in case they become incapacitated. So authors actually typically in a family trust are also beneficiaries. And in a family trust, the authors are also trustees. So if like the mother and father are moving in their trust property into a trust for the benefit of their family's well-being and for worst case scenario planning, they will typically be the trustees as well during their lifetime or until they don't get incapacitated. And they will plan for scenarios where they become incapacitated and where they are no longer in the world. They will also plan for scenarios where their children or their other family members who they care about, in case they develop some sort of incapacitation or disability. So this is the document that creates like this protective shelf around your family, where then for planning your smooth succession and for planning for these worst case scenarios, your dependency on external authorities goes down completely. Because then if something happens to you, your children and your relatives don't need to go and apply for probate certificates or succession certificates. They don't have to, take circles around the courts. Say if like something happens to you and you have minor children, they don't need to, then they're not left lost, right? There is no need to go obtain a guardianship certificate for them to have access to the necessary money they will need. So all of those complications go out of the window because you've done your job. You have created this trust. And what we also recommend is that in this whole trust structure, an observer also be appointed who is watching how this trust is going to function. And if there is any deficiency in the management, the observer, he or she can discuss it with the beneficiaries, discuss it with the trustees, mediate any possible conflicts or disputes. And if things are going really haywire, then they can also approach the court. So when building a trust, we think of sufficient, we put in place sufficient checks and balances in the structure that we have developed to make sure that your trust continues functioning in an effective way, and the trustees and the beneficiaries can keep optimizing the trust structure as life evolves. So it's a very dynamic document that builds a shell around your family and your trust properties and helps in the growth of your family and the assets. Also in the trust structure, there are consultants and advisors that come into play who work closely with the trustees. So there would be, say, you're creating a trust and you're already working with Hum Fauji, which is a great financial wealth manager. Some people also choose wealth managers as trustees to manage the wealth of the family. Some people choose to keep wealth managers as consultants and advisors to the family on the board. So this is how a trust functions. And if in case there are members with disabilities, then we also advise that you should have some kind of a consultant and advisor on board who's been addressing those issues for your families. Some people also choose to appoint such consultants and advisors as trustees. So basically, you are free to decide who are the different people you want to appoint as trustees in your trust. You are free to decide who you want to appoint as an observer in your trust, and you're free to decide who you want should be a guardian in your trust story. The benefit of a trust structure is that if you have like a
Just 1 minute, Pritika. Just got a message that there are 13 attendees who are waiting outside in the waiting room. Please make them join.
So there's nobody in the waiting room actually. Both Vishesh and I have checked, and it's an open link, so we can't see anybody in the waiting room.
So actually, the link shared was initially the older one. So there are 16, 17 of us. And finally, Hina has told us to shared the new link and have joined in. But for last 15, 20 minutes, there are 16, 17 of us on the old link where nobody was there. That's just for information.
Okay, understood. So just for everyone's interest, luckily we are recording this session. So for whatever everyone has missed, they can always go back and quickly check in. We're just starting, we're just getting into it. So when the 16, 17 people have joined this link, if you can confirm, I will very quickly give a recap of what we have discussed this far. That will also help the people who have attended so far to just summarize the structure. Can't hear you, sir. You are on mute.
So is it that those people who are in the waiting list have joined with an old link and not the new one, right?
It seems so, sir.
Okay.
No, it's not a wait list, sir. I was also part of that group. There were 17 of us there waiting since 10 o'clock. I think the link which was shared was taking you to some other meet. That's what I could understand out of it. I've told Hina about it. I put her there because there were 17 of us waiting, so I contacted her. She has given this new link and I've joined in. That's for your information. I told her to inform those 16, 17 through the old link to come back here. That happened 2 minutes back.
Okay, thank you.
We can have a 2 minutes break.
Yes. Good idea, sir. We will wait for 2 minutes and then we'll resume.
Govela sir, send them the message to join with the new link which is given in the WhatsApp.
Yeah, it's been sent twice. So I hope they join in. It's an open link, as Bambi said. Nobody seems to be joining in. I don't know where they're waiting.
Hi, Sanjeev. Ritu,
Hello, Ritu. How do?
I'm good, and I'm out in Jhansi, our regimental racing day happening, but I didn't feel like missing this. I had heard Preeti last time. I was so impressed, Preeti.
Thank you, ma'am. Thank you so much. Very encouraging. Thank you.
Yeah, but I'm not sure for how long can I be here, but I would certainly like to be connected with you. So I'm going to probably take your number, whatever, from Sanjeev, and
Yes.
later we'll connect.
So
Definitely.
Pritika, what you can do in the meantime is you can send in your number here
Yes, sir.
while we are waiting.
I will do that right away in the chat. And
You can send it in the chat, as also those people who have their personal questions related to this, because we'll not be taking up the personal questions. So you can give that Calendly link for them to have a free 30-minute chat with you later.
yes, sir. So we'll Vishesh, can you just share the Calendly link here in the in-call messages? The free consult link.
Govila sir, Air Commodore Rajneesh here. In my case, I could trace the link from the spam. So probably some of them might have got their email in the spam, so they can recover it from there.
Yeah. So, but there's no point saying it here because here are the people who got the right link.
Okay, there's no way of sending the mail again. Okay.
And I really don't know where are all these people right now sitting. I got a
Sir,
message.
have you shared the recording of the previous session?
There was no recording there.
Okay, right, sir.
So I think I will do a very quick recap of the trust structure.
We should just wait for one more minute because I think people are joining in.
Came in from the older chat address.
Yeah, they're actually in touch with Hina, and these people are trying to join. So just 1 minute extension request, Pritika, and then you can just brief. You can just summarize whatever we have covered up just now, and so that everybody is in the flow. Thank you.
Absolutely, ma'am.
Okay.
Yeah.
I'll request nobody to mute me, please. Somebody had muted me.
It must have been Vishesh eagerly doing his job. He's been assigned this role.
So while we are waiting, I'll also give a very good perspective to people about financial planning. We have a fabulous group called HFI Money Talks, which has, as on date, approximately 3,800 members. That is open only to armed forces officers and their spouses. And there, I hardly intervene. People are discussing their financial, Fauji, all kinds of issues there. So people may like to join in. We don't allow the children there, but only armed forces officers and their spouses are there. So I'll just give the link here. It is a Telegram link. Yeah. So I think we can go ahead now.
Great. So Bambi, maybe we can just slip into the previous slides and we will, or maybe we keep it here, actually. We keep it here and I will explain it from here itself.
Could you email the same link because we could note it down? Subsequently, we can have it from your emails to us.
Yeah. We keep sending it.
Right, sir.
Okay, so Bambi, move to the structure page. I will summarize it very quickly. So here we are talking about trusts and understanding how a trust is structured. What I see, one of the main benefits of a trust is that it helps you do your worst case scenario planning. So in the story, and the worst case scenario planning would include de-risking your wealth from your own self as you grow older. Also de-risking your wealth from the possibilities of any of your family members developing some sort of disability, or from you passing away too soon, leaving behind minor children. So these are the different kind of scenarios that trusts help us address. It's a great tool to also plan for a future where you might have children who have some special needs, or even adult members who are differently abled. They could have mental health issues. They could have physical incapacities. There could be blindness. There could be like any spectrum of issues. So that's where the trust structure comes into play. So in your trust structure, as you can see on the left top, there are authors of the trust. These are people who own the trust property, which is going to be used to create a safe space for their beneficiaries, with the help of trustees that they will use, who will manage the trust property as per their instructions, which will be laid down in the trust document, which is often called a trust deed or a declaration of trust. And the authors will lay down detailed instructions there. They will talk about the objectives of the trust, the purpose of the trust, how the trust property will be managed by the trustees for the benefit of the beneficiaries. You must also note that authors of the trust in India can be trustees themselves during their lifetime and until they are incapacitated. They can also be beneficiaries. So when you as an author of the trust are creating a trust for the benefit of your family over your assets, you do not lose control over your property per se. You are simply protecting your property from the world outside by creating this very safe system for your family and for yourself. The trust structure also helps in making sure that the succession is smooth, that there is no need for obtaining a probate from a court, or a succession certificate from a court when it's time to execute wills. Wills, like we have discussed earlier, are minimum standards of protection. Through a will, you just list down your assets, you decide how your property will be distributed one time with the help of your executor. You don't do worst case scenario planning there. The worst case scenario planning happens through the trust structure. When you only create a will, your family will eventually, if you're domiciled in the presidency towns like Bombay, Calcutta, Madras, you'll need to obtain a probate, which is like a validation from court. Takes up to anywhere between 1 to 3 years to get a probate. It's a long drawn, expensive process. You also have to pay court fee. You also, in case you're in other cities or other states, there some departments, even if there is a registered will ask for a succession certificate. So creating this trust gets your family to get rid of those issues, and during your lifetime you continue to be trustee and you continue to be beneficiary under a trust structure. So these are some of the benefits that I clearly see a family trust having. I'm also seeing rising cases of autism in families, schizophrenia, bipolar mood disorders, other kind of undiagnosed anxiety disorders. And I find that it's becoming increasingly important for families to actually plan for themselves, because a lot of us believe that we have a state that will plan for us, or there are judges that will take care of our children, or police. Somewhere deep down inside, we are not doing all this because, one, either we are not aware, two, because we somewhere deep down believe that there is an external third party system like your state, etc., that will step in to protect our children, or our family members. Well, theoretically, yes, but practically, I've been practicing for close to 20 years now. That system does not exist. It's really, really broken. So repeating this again, your wills and your trusts are your system to protect your family, and also to protect your family from the external systems which are broken. And once you create these planning tools, your families are still have a better chance at actually managing these external systems in their favor. So repeating the benefits again, some of them, there are many more, you will see as you continue learning around trusts. There's no need for probate or a succession certificate in case you create a family trust. You get to do your worst case scenario planning, which starts from de-risking your own family and wealth from your own self as you grow older. Also, you get to protect yourself. There's so many instances where people don't have children, or the children are outside the country, or are busy with their own lives. So you can use the trust structure to write down the system that will come into play once you reach a place where you need help. You may also need to help your children. This could be some disability, or this could just be the way that the world is going. One needs better planning. So you can plan a system for them through this, imagining different scenarios, not just for children, but also for people with disabilities. You could plan a better, healthier life for your older parents in case you're in a place where you're not able to take care of them. These are some of the benefits I'm seeing. Also, it's a great tool for risk mitigation from disputes. Many families are fighting. There are many couples that are fighting over the maximum disputes in the country are really emerging from real estate disputes, family disputes. Your trust is a great tool to mitigate that risk. I'm not going to say that it totally takes away the possibility from someone disputing what they want to dispute. But once you create a trust, it substantially mitigates that risk, because conceptually you have moved in your property into the trust, and now the trust owns that property, legally speaking. Although really speaking, you continue to own that property. You get to decide and call the shots on how that property will be managed. But this is a smart concept in law through which you can say, well, I don't own this property now, it's with the trust, and so like you can't dispute with me over this property. So conceptually, this is a great defense from third party disputes. This will also help you protect your family and grow your family wealth and keep your family together. So these, anything that comes to your mind, Bambi, would you like to add something here from a structure and a benefit point of view?
I think you've covered it really well, Pritika. And yes, of course, I think you've already touched upon how, especially when there are vulnerable, family members, or there are certain illnesses that do run in the family, and you want to, de-risk from yourself as well. It's much better to rely on a family trust that's already been set up and is functioning, rather than just have a plain will and try to appoint guardians under that. Because like you mentioned, once the will comes into effect, and if there is no trust, if there's just a lot of running around courts trying to get these guardianship certificates, trying to even get access to funds, to the financial funds, can be a big problem. And especially when you're already in such a vulnerable space, that's not a problem that you want to have. So if you already have a family trust in place and you've already done enough future planning, then you can mitigate a lot of the issues and delays and problems that would otherwise arise under a simple will.
Yeah.
Mhm.
Bambi, can I request you to move to the slide where we discussed the nature of a trust? With this overview, I want to discuss now. I'm just going to touch upon these principles again, which go into creating a trust deed, which Bambi had discussed earlier. So when you are creating your trust and when you are laying down the instructions that you want the future trustees to follow once you are no longer part of the world, or you are incapacitated and can't play trustee anymore, then those instructions are usually of this nature. They are either discretionary, which is that you trust the trustees enough. This could be a spouse, this could be a child in the future, this could be a friend, this could be an advisor that you have worked with for a long time. You could give them discretionary powers to decide how your trust property will be managed for the benefit of your family, which is going to be the beneficiaries in the future. Or you could make it more specific, determinate. The instructions could be more specific, where you say, I'd like my children to get this XX amount when they reach this age, like say when they turn 18, 25, 35, 45, or when they go to college. Like you can be more specific, where there would be very less discretion with the trustee. Or you could be you could give them that discretionary power if there is enough faith you have in them. Also, you could give mixed instructions. For some aspects of your planning, you could say, okay, this is fixed. For these decisions, I'm very clear, I'd like you to follow these specific instructions. But for a couple of other decisions which are more dynamic in nature, you could give them discretionary powers. These are hybrid private trusts. Typically, as we are drafting these private family trusts, we are seeing what works best for families is a hybrid nature. There are some specific decisions and there are some discretionary decisions that the trustees can take in future. And then, of course, a trust can be revocable or irrevocable. A revocable trust is a trust that the authors can revoke, or it can be a trust which the authors cannot revoke. But be mindful, even if you create an irrevocable trust, it doesn't really matter. Even if you create an irrevocable trust, you don't lose control over your wealth, because ultimately for as long as you're part of the world, you're going to play trustee. Also, the way that you're going to draft your trust deed with an expert, it's going to be drafted in such a way that you will always have access to the funds attached to your trust property, to the profits attached to it, to the income attached to it. So with these thoughts, Bambi, we can go to the next slide. Yeah, okay. So now moving to scenarios where actually we do come across a lot of people who have assets in India and abroad. So we thought that it's best to also discuss some of these cross-border scenarios. In case you have assets which are in India and abroad, then we would recommend that if you are choosing to create a will, you create an India will, because ultimately, if you're an Indian citizen, you should be creating a will in India, because that's really going to, in case of a dispute and all, our courts function differently than the courts outside, and we will always get more attention here than anywhere else in the world. So we also see this practically happening. So we would recommend that if you have assets that are spread across, and we are seeing increasingly families are moving in that direction where they have assets, say in India, in Dubai, some have in Malaysia, some have in the US, some have in Canada or the UK. So we would suggest your principal will should be a will in India, including your assets in India and outside India, and get it registered in India. Now, if you also have, for instance, some assets in Dubai, then we would recommend that for the Dubai specific assets, you get the will registered with the authorities in Dubai, which is called the DIFC authority. We also help with all this. And after the author passes away, you can get the will probated in India, and you can use that probate and submit it abroad for execution of the assets that are outside India. So this is how your asset management under the will work in case you have assets in India and abroad. The principle that you need to keep in mind is the principal will should be in India, and it should include all your assets in India or abroad. And for outside India, whatever assets you have there, keep like a mirror will ready for those assets. Bambi, we can move to the next slide.
Yeah. So similarly for trusts as well, we do work with a lot of NRI and OCI clients. And similarly for a trust, what our recommendation is that if you have Indian assets and you also have foreign assets, it's best to create separate trusts. So an Indian trust, which covers only your Indian assets, and a foreign trust, which covers your foreign assets. And how we help structure them is that if you already have a foreign asset trust and we're creating your Indian trust, then of course we look at the nuances of your foreign trust, and we structure the Indian trust in a way where, although the two trusts are entirely separate entities, we keep them coordinated so that there is no ambiguity or complexity there. So this is our broad, recommendation in this aspect. Okay, coming to the tax implications and the stamp duty implications around a trust. So when it comes to tax implications, under a trust, there is this misconception and misinformation that's been going around that private family trusts are a great way to, avoid tax or to minimize your taxes. But actually, this is not correct at all. This is not right, because trusts are not used to optimize tax. Whatever tax has to be paid will be. The only thing is that when you create a trust, and depending on how your trust is structured, like we discussed, whether it's revocable, irrevocable, discretionary, fixed, or hybrid, depending on the structures that you choose. It's just that the tax is paid, in a different way. So to simplify this for you all, let's say you have created a private family trust which is revocable. So as we all remember, revocable means that the authors of the trust, that is the people who own the trust property and are putting it into the trust, they still have the power, right, to terminate this trust so that everything goes back to them. So in such a scenario, the tax implication would be that while the trust is functioning, whatever taxes have to be paid, it will be paid in the hands of the settler themselves, because it's a revocable trust. At any point, they can choose to terminate, and everything goes back to them. So whatever taxes are to be paid will be paid in the hands of the settlers themselves. Now, on the other hand, let's say it's an irrevocable trust and it's a discretionary trust. So now it's irrevocable, so the authors don't have a right to terminate, right? On top of that, we're saying it's a discretionary trust. That means there are no fixed payouts, there are no fixed amounts, there are no milestones. It's on the discretion of the trustees. Now, in such a scenario, whatever taxes need to be paid, they will be it's basically the trustees who will become the representative assessee under the Income Tax Act, and the trustees will pay this tax on behalf of the beneficiaries to the government authorities. Now, you must be wondering, but how will this be decided, like, the amount of tax, because there is no fixed amount. So as per the principles that we have under law at the moment, if it's a discretionary irrevocable trust, the trustees will be taxed at the highest MMR. This means that if you look at the individual tax slabs that each beneficiary would, be subject to, the highest of that will be taken, and the trustee will be taxed on all those amounts at the highest MMR. So now that is for a discretionary irrevocable trust. Now, let's say it's not a discretionary irrevocable trust, it's a determinate or specific, irrevocable trust. Here, it means that the trustees don't have the discretion, right? There are fixed amounts, fixed milestones, fixed payouts that have been determined under the trustee that are supposed to go out to the beneficiaries. So here, by logic, it would be very clear which beneficiary gets how much amount at what point of time. So here, the tax, it will be all these amounts will be taxed in the hands of the beneficiaries themselves, subject to their individual tax slab rates. So this is the difference between, this is how basically the tax is determined and paid depending on how the trust is structured. So it's not that you can avoid it entirely, but it just depends on, how it's structured and who has to pay it in what capacity at what point of time. Another point I want to add is that if it's a irrevocable trust, that means it's not going back to the author at any point. Then when you are moving your trust properties into the trust, there is no capital gains tax that is applied. So there is no capital gains tax under an irrevocable trust. But on the other hand, as per a latest amendment in the Income Tax Act, if it is a revocable trust, that means if, the author can choose to terminate and everything goes back to him, then yes, it is highly possible that there will be a capital gains tax that will be applicable for even putting your properties into the trust, which is why a lot of people do choose to go ahead with an irrevocable trust. So that's on the tax aspect. If I've missed out anything, maybe Pritika, you can add to it and then you can explain.
You covered it fair and square. And what I want to add to this tax conversation is that, I am of the sound belief that trusts are not for tax optimization. They're for worst case scenario planning. So please do not pay too much attention to this tax story. Please design your trusts in a way that your family and wealth is taken care of. There will be a little bit, maybe like a little fraction of money that, maybe one may pay a little more depending upon irrevocable or whatever, like one of these natures and all. Sure, effectively manage it, but don't pay too much attention to this. This is not why trusts are used. And don't there are a lot of practitioners who focus so much on this tax aspect that they take away from the real benefits of trust management. So please focus on the benefits of creating a trust rather than thinking that trusts are being used to save taxes. No, trusts are not used to save taxes. The other points that come to surface a lot when we are discussing trusts and when we are creating trusts is, how much stamp duty will I have to pay when I move or transfer my immovable and movable property into the trust? That is, when I make that a trust property. This is a very interesting question, and with a very simple answer, actually. Your movable assets are assets that are regulated by the center. So under the Indian Constitution, which we call the fundamental law of India, which is the grand norm of India, there are two lists. There are state lists and there are center lists. So under the center list, which is also called the union list, there are subjects that are listed there which are regulated by the central government. Under the state list, there are subjects which are regulated by the state government. And then there is a list 3, which is your concurrent list, which has subjects which are regulated by the state and the center. And then there is story around, what will prevail in case there's conflict under list 3, but we are not going there. Right now, we're talking about just the state and the center list. So movable assets and the payment of stamp duty on movable assets is a subject that gets covered under the central laws. And as per the central laws, there is no stamp duty that is payable on transferring your movable assets, which is your shares and your debentures, into a family trust. So this is, and this applies across India. Now, when you are wanting to move your immovable property into a trust, which could be your house, your land, your apartment, your office space, anything immovable, then depending on the state that you are in, you may or may not need to pay stamp duty. In my opinion and reading of the Stamp Act of India along with the different state acts on stamp duty in India, I find that, for example, in Delhi, if I am declaring a trust over my property, then the Delhi government takes stamp duty from me on moving my immovable property into even a family trust. They take stamp duty like they take on, say, selling a house, which is about, I think, 5% of the circle rate. Here again, I would encourage you to not pay too much attention to this aspect, especially if you have a family where there are vulnerable members. It's worth paying that stamp duty and moving in your immovable property, because once you become incapacitated or once you pass on or either of these things happen, how are they going to manage the succession of that property, go to courts, go to these revenue officers, get the mutations and all done? It's a nightmare. One, they will not be able to do it if they are vulnerable. Two, it will be, if not as expensive, it will be more expensive. And 3, it may never get done. So if you have this kind of vulnerability in the family, please move in everything, pay that stamp duty. Now, if you'd like to avoid that stamp duty, some amount of structuring can be done. You can change your movable property into some other state. In my opinion, in Tamil Nadu, it's really one of the Madras High Court is really one of the finest high courts of India. Their judgments are really beautiful, and they have opined on family trusts and application of stamp duty on family trusts very differently. They have taken an interpretation that no stamp duty is applicable on declaring trust over immovable property for your family. And they've done this repeatedly. So over there, if you had immovable property and you moved in your property into a trust in Tamil Nadu, in my opinion, you will not need to pay stamp duty in that jurisdiction. Similarly, in places like Goa, if you have land and immovable property which you move into a trust, you can simply gift the immovable property to the trust, because the gift, because the stamp duty on gifting in Goa is barely 5,000 rupees. So like this, you can decide how and where to make your trust based on stamp duty and how to structure your wealth that you want to protect for your family. So yeah, these are our thoughts on tax and stamp duty. Bambi, anything that I missed on stamp duty that you'd like to add?
I think we can also share with the attendees that another way, if I'm not wrong, if you haven't already touched upon this, is that for immovable property, it can also be pushed into the trust through the will.
Oh yes, that's an important
also,
aspect. Yes.
yes.
Now, if you are someone who does not want to pay that stamp duty to the government on immovable property, then the way that the trust is structured is that the trust gets drafted, the trust gets created and set up. At the time of setup, it's simple. Once the draft is complete, you're satisfied with it, your lawyer is satisfied with it, you move in, you get it registered. During the registration, your trustees have to sign it, and your witnesses have to sign it, and authors have to sign it. Beneficiaries don't have to be there. After that is done, basically a PAN card is applied for the trust. Once the PAN card is received, a trust account is created, and your movable assets are delivered into the trust account. So if you have a demat account, you can deliver that demat account to the trust, and there will be a trust demat account where your securities will be managed, which are dematerialized. The other stuff can be physically delivered. So there are mutual funds and all. If you haven't dematerialized them as yet, then those can be physically delivered also. And once that, so this is for setup and moving in the movable assets. Now, if you don't want to move in the immovable assets immediately, you can choose to move in the movable assets immediately. And the immovable asset you can retain a will for, where it will say that such and such immovable properties of mine will go to the trust on my passing. And in that case, in our opinion, because that becomes part of like your testamentary disposition, there then stamp duty should not apply when that property is getting mutated in the name of the trust. Now, how is property held in the trust? Basically, it gets held for the sake of management of the trust. Property of the trust is held in the name of the managing trustee for the benefit of the beneficiaries. So the records of the government for immovable property will have the managing trustee's name, and nothing to worry there. That doesn't change the beneficial ownership of those properties. That remains with the beneficiaries of the family. And also you should keep in mind that the Indian Trust Act puts a fiduciary duty on the trustees. So at no point can a trustee, after accepting that trust, can act out of the trust. There are obligations and there are consequences for breach of trust, and they become personally liable in case of breach of trust. So these are some following thoughts on this, on structuring your trust.
Okay. So now we're on the last leg of our presentation, and we want to touch upon guardianship for both minors and also people with disabilities. So when it comes to guardianship for minors under the Hindu laws that we have presently, we have the Hindu Minority and Guardianship Act, which applies to Hindus, Sikhs, Buddhists, and Jains. And I think Pritika did also touch upon this briefly in the last webinar. So if you all recall, as per the Hindu Act, the father is the first, natural guardian of the child, and the mother is the second natural guardian. And both mother and father, can create their wills and trusts, and they can appoint guardians for their minor children under these documents in case both of them, are not around tomorrow. So practically speaking, what happens is that, if the father appoints a guardian, under the will or trust document and goes away, but if the mother is still alive and she's capable, of course, of taking care of the child, then of course the mother will continue to, be the guardian and of the child and have their custody. Similarly, if the mother, leaves behind a will or a trust document appointing a guardian, but the father is still around and is capable and is not disentitled, by a court of law, from taking care of the child, then of course the father will continue to be the legal guardian of the child and have the custody of the child. Of course, we see that today, relationships and families have become more complex. There are, custody battles that take place. So this is a more nuanced area. And of course, let's say there is a scenario where, a mother is divorced from her husband and has complete custody of her child, and the father asks for the court order because of his issues, say of alcohol or otherwise in the past, only has visitation rights of to visit the child, and the court recognizes that he's not really a fit father and that it's the mother who will continue to have custody. Then in such a scenario, let's say the mother passes away and appoints guardians under the will or trust, and let's say the father has not improved and does not have custody, is also completely disentitled, not at all fit to take care of the child, then the court will recognize that and will say that it's the legal guardian that's been appointed under the documents should have the sole guardianship or custody of the child, and the father will then continue to have those same conditions imposed on him and have only visitation rights. So my idea of giving this example is that there are nuances to this, but broadly this is how the law has been drafted. So now coming to the next act, which is the Guardians and Wards Act. So now whether a guardian has been appointed under a will and trust document or not, the Guardians and Wards Act is the primary act where anybody, whether it's a relative, whether it's the guardian appointed under the will or trust document, or anybody else who cares about a minor, can go to the court and apply to be the guardian of the minor in question, or to recommend somebody who they feel should be the guardian in this particular case. And the court will then, of course, either want a copy of the will and trust document if there is one in place. If there isn't, then other documents and particulars will be required. There will be interviews and investigations that will be conducted to make sure that the guardian is willing and is capable to take care of the minor. And of course that if everything looks good and everything is in order, then the court will go on to issue a guardianship certificate. Now, practically speaking, this guardianship certificate is an important document because it's the only way you are really authorized in the real world to act on behalf of this minor. So let's say you have to get a passport for the minor, you have to open a bank account for the minor, you need to get control of the funds, in the existing bank account on behalf of the minor. All of these things, practically, the banks and the authorities will want to see a proper authorization that, yes, you are authorized to do all of this on behalf of the minor. So they will want to see the guardianship certificate that's been issued, by the court or by whoever is the competent authority to issue that at that point. And that guardianship certificate will also have other conditions that the court, will impose, on the guardian in terms of handling the property of, the minor. Because the court will always look at the welfare of the minor, both of the person and also the property of the minor. So these are some very important concepts, under these two acts. And what more I want to say is that, see, if you just leave behind a will that simply appoints, just names a person you would want as a guardian, then that's not the way to really protect the minor that you're leaving behind. Like Pritika mentioned before, it takes a while, practically, realistically speaking. it takes, it can take a couple of years also for the courts to issue such a guardianship certificate or even start looking into this manner. What if the will goes into dispute, other people are disputing it, and it's just, stuck in court for years. You're not able to get access to the funds. Um, there's a lot of problems that can arise. Whereas if you create a trust and you do deeper planning in terms of who the guardian should be, who are the backup guardians in case the primary guardian is not available or is unfit, what are the funds that have been kept aside in the name of the minor for the guardians, what all should the guardian do, then you've still created a safe system for your minor, and for your minor to still have access to those funds while all of these other things are being done, practically on ground. So that's on guardianship for minors. I think we can now move to guardianship for people with disabilities.
Great, thanks, Bambi. Just something I'd like to add to the last slide is that the trust is helpful even while managing guardianship for minor children, because once you've chosen your guardian, the trustees can, as per your instructions, hand over the funds that the guardian will need to glide through that process, because the guardian that you appoint will not have access to your funds. The trustees will. So typically when you have a will and you appoint a guardian, the guardian cannot have access to your funds until the guardianship certificate is obtained. So by creating the trust, you have overridden this, I would say, this hurdle that otherwise exists in the legal systems of the country. Now moving to guardianship for people with disabilities. So if you're looking at a scenario where this is a disabled child or a sibling or a parent who's over 18 years of age, guardianship gets decided under the National Trust Act or the Right of Persons with Disabilities Act or the Mental Health Care Act. The National Trust Act takes care of more severe disabilities like cerebral palsy, like autism, and like a mix of these, or if you have multiple disabilities. It also requires a parent of an adult member or a sibling or a relative to apply for guardianship for that adult relative in case they want to help out. It's not mandatory, but if you want to open a bank account for your members with these kind of disabilities and you also want to help co-manage their funds, then you will need a guardianship certificate under the National Trust Act from the relevant authority. It's called the local committee. Similarly, if this is a less severe disability, it will get covered by the Mental Health Care Act and the Right of Person with Disabilities Act. Here again, you will apply for guardianship certificates to help such people with disabilities. But then again, these acts are a great starting point for the country, but they don't really, provide much to help these people. So the only help that you can give to people with these kind of disabilities is, frankly speaking, through the trust structure. You have to create your own trust to help them. There's no point relying on a third-party trust structure, which is not tried and tested, or single-handedly by yourself. So best to create your own family trust to manage these kind of situations. So that is it on guardianship for people with disabilities. So what we've learned is guardianship for minors is dealt with separately under the Guardian and Wards Act. Guardianship for adults is dealt with, and especially adults with disabilities, is dealt with National Trust Act and Right of Person and Mental Health Care Act. This is something that lawyers usually take care of when making applications for guardianship. So with this, before we jump into the Q&A, I'd just like to take maybe a couple of minutes to see if any one of you would like to, reflect on why you think you need a trust and why is a will not enough. So I'm going to open the stage to hear some of your reflections on these questions, if you'd like to contribute to the audience here, and then we'll open up the questions. Yes, this is showing up, the name is showing up as PK Interiors.
Yeah, I'm Kanal Kumar. I just
Yes.
want to know, is HUF and trust, is there any similarity or they are different products?
Colonel Kumar, we'll take up the question separately.
Okay.
Your question, which you have posted in the chat, is already with us.
Okay.
So, Pritika, what we'll do is, there are plenty of questions. So we will just go ahead with them. Is that fine with you?
Yes, sir, absolutely. We can start with the questions.
Okay. Before I do that, I would like to announce one more thing. When I've gone through the first, second, and now this third one, I feel that wills, trust, succession planning is a very, very important part of our lives. But then I also feel that there should be one more webinar, which should be a sequel to these succession planning webinar series that we've had. I've not conducted a webinar in general for a very long time, and I would really love to conduct that webinar. And I would like to call it 5 Smart Financial Steps every armed forces family must take for a blissful life. Right? So I'm just posting it in the chat. All those who would like to go ahead with that, it'll be great. And this will not merely be about investments, but about the practical, smart actions that every armed forces family should take to secure their present, prepare for their future, and also ensure a true peace of mind. We would cover following things: how to build a financial shield around your family so that no uncertainty shakes your peace. Then the right way to balance today's lifestyle with tomorrow's needs. Simple steps to avoid common money mistakes we see happening in armed forces family all the time, day after day, month after month. So much of it that sometimes we, feel as to we've not been able to create even a ripple in the whole ecosystem, Fauji ecosystem that we've been trying to do for 15 years now. Then how to create a roadmap for children, retirement, and beyond. And finally, how to tie all this together into a life of financial confidence and bliss. Is going to be a practical, relatable, and designed especially for our Fauji families. And I very, very warmly invite all of you to join next week and bring along your Fauji friends and course mates and whosoever you think you should be, benefiting them. So try not to miss this. I'll be putting in a lot of effort, and my 15 years of, financial planners journey, the experience will go there. I'll just be posting a link for that. So with that, we go ahead with the questions that have come in. Are you ready, Pritika? We go ahead.
Yes, sir. Yes, sir.
Okay. The very first question that has come is, for a single parent with a minor child, how can we protect the interests of the child if there's really no guardian in the family?
Very interesting question. In that case, we would recommend that you need to start looking for an external guardian. You need to start the search now. You need to choose that guardian. The guardian need not be a family relative. It can be a family friend or a friend that you build a relationship with as you go along. There are also many experts that are out there in the market who are doing a fabulous job. Like how Bambi and I are passionate about law, there are many people, many professionals in their, I would say, late 30s and 40s who are very interested and very invested in managing the well-being of children. So we would recommend that these are things that people don't think about that much, but one must, especially with minor children. So we would recommend that you start searching for these people and building a relationship with them. Some of them are working as counselors. Some of them are generally working with children to help them with their mental and emotional well-being. So we would recommend that you start looking for these people. There are no institutions and there are no organizations in the world which will solve this problem for you. This is a planning and a research duty that you have. So you need to do this as a parent.
Okay. The next question is, any recommended value of property or type of trust where will should be done and where trust should be done? Basically, he wants to know as to what is the differentiation. When should you decide I need a will or I need a trust?
Yeah, so thank you for this question, and we hear this a lot from our contemporaries and from some banks that also create trusts which cap a figure on when a trust should be made. This is total nonsense. If you have vulnerable family members, if you have minors, whatever you have created, it could be 50 lakh of rupees, it could be 20 lakh of rupees, it could be one house, one flat. That's your world, and that's enough. You need to protect that for that minor. So you really can't put a cap on when it's the right time to create a trust in terms of, the amount of money you have. So based on the need for that trust, I think when you need to create a trust, you need to create a trust. So no financial caps or requirements in law on when a trust can be created and should be created. Whatever you have is enough to create a trust.
Another very good question, and that is there any difference between a HUF, Hindu undivided family, and a trust? Broadly, they appear to be the same. Is actually a HUF a kind of a trust?
Again, very interesting question. And the Indian income tax does treat HUF, which is a Hindu undivided family, and a private trust differently. Conceptually, they can pretty much be working the same way. I don't know what you have in mind when you talk about a Hindu undivided family, because this is really a concept that I see a lot of chartered accountants have pushed around in our country in the past. The term could have so many different varied meanings based on the document that has been used to create a Hindu undivided family. So there is no very, very clear distinction that has been laid down anywhere. It is possible that a Hindu undivided family is structured like a trust. It's possible that it has not been structured like a trust. So very difficult to give you a clear answer to this question on this call. I'll have to see the document that is calling itself a Hindu undivided family to see if it is a trust or not. So it is not a given. It is not a given that a Hindu undivided family is a private trust.
Next one, in a determinate trust, can I mention that I would like certain amount to be given to X from my property, who's not a part of my family on my passing away?
Yes, you can, but if the beneficiaries are outside the family and are not relatives, as relatives have been defined in the Income Tax Act, then this could have certain negative tax implications on the trust. So we would not recommend that unless you're okay with the negative tax implications.
Okay.
You can keep that money outside the trust, and to that extent you can create a will. I would rather have you do that.
Okay. Next question, can we carry out activities of charity with a private family trust, and what will be the tax implications?
So very interesting question again, and what typically we see is that you can give a gift to a private charitable trust. That can be one of the purposes that your private family trust follows. And in case it's a gift that you're giving to a private charitable trust as part of the functions of the private, it's going to be a gift. So when you give a gift to a non-profit, there should be no negative tax implications on giving that gift for that charitable purpose, and whatever tax benefits are available for giving this sort of a contribution will be then availed by the trust on your behalf.
Can a trust deed be amended subsequently?
Yes, a trust deed can be amended at any time based on the instructions you laid down.
Okay. A question, not part of trust, but my father's house will be shared between 3 siblings. Can I include it in my will?
My father's house will be shared by 3 siblings. Can I include it in my will? Yeah, if you'd like to distribute the ownership of a house that you have received from your father, your share in it for, I would imagine these would be your children, just for like answering your question, there is nothing stopping you from doing that. It will be distributed between the 3 children.
No, Pratika, the question is slightly different. It is in the matter of postulating that the father's house is there and there are 3 siblings. So the person is asking whether in anticipation I can include my share as part of my will.
Yes, you can. Yes.
But it is based on a premise that his father is gifting it to. I mean, the house is passing down to the share is passing down to him anyway.
So it'll depend on how you draft it. You can always draft it conditionally. Should I get any share from my father from this property, then that will go in this manner.
Okay, right. So next one is how to go ahead with designing of the trust, whose assistance to take. That question I can answer. Pritika has already spoken. Plus Pritika and Bambi's company, NoGrey, they themselves are, I think, one of the finest ones doing this in this space. And I really don't think you should be looking elsewhere, unless, of course, you have somebody else who you have more trust on. It is up to you. Pritika, anything to add on this?
That's perfect, sir. That's exactly what I wanted to say.
Yeah, great. Then a question about what about stamp duty in Bengaluru/Karnataka and other states? Because when you spoke about how states are treating the stamp duties separately, differently.
So on movable assets, so if you are moving in your shares and debentures into the trust, there is no negative stamp duty implication. If it's immovable property, then from when I checked last in Bangalore also, there is something like anywhere between 3 to 5%, I think, on declaring a trust over your immovable property. While we jump to the next questions, perhaps Vishesh, you can quickly pull out the schedule for Karnataka and check what is the stamp duty on declaration of interest of declaration of trust in Karnataka for us, and we can share that at the end, like a definitive answer to that.
Yeah, I think this is where Pritika, there is a. Can you please mute Mr. Vinod Dhingra? Yeah, thank you. Now, I think that is where the difference between trust and HUF comes. If you move any financial assets, movable assets also into a HUF, you have to pay the duty, etc. You have to pay the tax, etc.
Yes, so that is also going to be treated as a settlement between the family. So settlements and trusts from a stamp duty implication, some states treat them differently, but I'm seeing that the amount of stamp duty almost comes to be the same amount.
No, I'm talking about movable things which come under the center's purview. I think when you move it to a HUF, then it is treated like a transfer, right?
So the thing with the movable also is that when it is a value-free transfer, it is treated like a gift. And even if it is a movable that you're moving into an HUF or a trust, The stamp duty there is no stamp duty payable on it.
Okay, right, right. Now, next one is, can a trust property, movable or immovable, be sold? If yes, who signs in as the seller and where does the money go to?
Yeah, so yes, movable and immovable property can be sold as per the instructions given in the trust deed. And the person who will have signing authority would be the person that you would appoint, who should have signing authority in your deed. In the system that we have developed, we give that authority usually, unless the client wants it otherwise, to the managing trustee. So basically, the managing, whoever you appoint, it can be yourself during your lifetime, you will sign those documents, or whoever you choose.
Okay, right. If you have immovable properties in 3 states, say Punjab, UP, Haryana, then do you require one will or 3 wills or trusts?
One is enough. One will or one trust, or one will and trust.
Okay. One very odd question. In case of a will, to avoid issues later on, can the succession certificate be made /probate done when one is alive?
Yeah, we are trying to find a solution like that. We haven't yet found it. When we do, we shall definitely share it with the whole crew. But right now, no. You can't
Okay.
get a declaration beforehand.
Okay.
There are certain tools in the Civil Procedure Code that we are exploring. We haven't found a precedence to it, but if anyone would like to test it out with us, we'd be happy to, use one of those principles in the Civil Procedure Code as a test. But no one has tested those principles as yet.
Okay, that's great. That's great. I thought the answer was straight away, no, it can't be done. So you are really looking at a solution to this.
Yeah,
Great.
sir, the code is such a beautiful code, the Civil Procedure Code. There are so many principles there which actually, our society is not using to its benefit. So, we as an innovative team encourage people to use these principles when they're ready. They are there. There are various, provisions that can be used, but it has to be tested because we don't know how the courts will respond. They'll have to be pushed around a little bit. It has to be tested.
Okay. And then a question slightly pertaining to the previous webinar, will versus settlement deed versus relinquishment deed if the will itself is problematic. I'll just repeat. Will, settlement deed, and relinquishment deed. That is what the difference. If a will is problematic, as you brought out.
Yeah, so if there is a will and that is problematic, and the beneficiaries under the will do arrive at a settlement, and they also sign a relinquishment deed if need be along with that, although the settlement agreement will be treated as a relinquishment to the extent necessary, that should be okay. That should be fine.
Okay. With the increasing cases of divorce, can setting up a trust for children help to protect the family wealth from alimony?
Yes, definitely. And it will definitely help in mitigation of the risk of that sort of a threat. And because then in that case, your children no longer at any point conceptually own the property, the trust owns it. So conceptually, if you have done it beforehand, then the third party can't come and contest that this is a sham trust and it's been created to take away my rights. So yes, it will help in protection against claims for alimony. It will be a huge protection. Very, very difficult for an alimony case to win against a trust structure. And in fact, we are also seeing and encouraging young couples to look at trust as a structure similar to a prenuptial agreement. India doesn't have a law on prenups, but we are recommending that trusts be looked at to even financially plan marriages now.
Okay, right. Sometimes old property documents have older ranks, say major mentioned on property registration documents, Although the name in Aadhaar card is without rank and the current rank is different, how to resolve this issue? Do we need to re-register the property?
So actually, one practical and also a legal solution to this would be um, that whenever you're trying to sell the property and if there is an objection because of this issue, usually the authorities will accept an affidavit. And that should be enough and should help in facilitating the transaction. You don't need to go and change the document and the name and all or anything like that. Is there a difficulty that you have faced? If you can share the difficulty, then perhaps I will be able to give you different insights. Okay.
Okay, we'll go ahead. Can we start a business company by funding from assets of the trust and route a part of the profit back to the trust to make it sustainable forever and balance back to the company or shareholders of the company oblique business? Do I repeat?
Yes, sir.
Can we start a business company by funding from assets of the trust and then route a part of the profit back to the trust to make it sustainable forever?
Yes,
and the balance.
absolutely. You
And
can
the
do
balance, balance back to the company or shareholders of the company oblique business. Is it allowed?
balance back. You can structure your private trust however you want, as long as you're not doing something unlawful. So there is nothing unlawful in this structure. So yes, you can do it. It'll have to be worded accordingly, or as in when the time comes, it'll have to be amended accordingly to provide for this sort of an investment. Ultimately, a family trust can make whatever investments it wants.
Okay, right. So it is pretty flexible in this regard, and it is up to you how you wish to do it, as long as it is within the rules of the game, right?
Yes, sir.
Okay. Which trust, revocable or irrevocable, is better, and what are the reasons for it?
So I think an irrevocable trust is better because it does give you the advantage of not having to pay capital gain taxes by the trust when you create it and you move in your assets into it. And I don't see any advantage of a revocable trust in India. So I would recommend an irrevocable trust for families.
Okay, right. Next one is, how can we ensure the interests of special needs adults against interest of the trust members?
So the way to do it is to actually, in the structures that we have developed, the way that we are balancing these human issues is that while there are trustees, there are 2 to 3 trustees, we also encourage appointment of an observer who's independently watching how the trust is working. The beneficiaries are also being regularly informed. There is also a guardian who is separately appointed. So in trust structures where there are, members with disabilities, we not only have a trustee, a board of trustees, which is managing the wealth. We have a guardian who is managing the emotional and mental well-being and physical well-being of the person with disability. And then we have an observer who is watching the trust, the trustee and the guardian and the beneficiary who has the disability. And if anything is not going right, the observer is given the power to approach the court and ask for, first try to resolve it within the trust, get the guardian changed and all of that. Secondly, if that's not working, then approach the court and ask for assistance with appointment of a new guardian. So this is the extent of risk mitigation that we have thought of in the structuring that we have done. But I'd also like you to remember that at some point, then after all of this structuring, you have to have faith. There are no absolute guarantees in life, but this is the maximum amount of planning that you can do. This is the best that you can do at your end, with making sure that these trusts have trustees, observers, and guardians.
Uh, Somebody asked you, Pritika, you just spoke of a conditional statement. Is it possible in case only in case of a trust or in a will too?
What sort of a conditional statement would we
I,
have in mind here?
yeah, you
Yeah,
something, and
it
I
was
think
me.
yeah.
Yeah, it was me. You just said that you can mention that this property will pass on after my death. So that is a conditional statement when you are answering some question.
The property will pass on after my death. In the will,
You
sir?
you mentioned something like this while you were in answering about a question about 5 minutes ago, just before my question. My thing is, can conditional statements be made in a will? Like they say that whatever you write in a will, unless you change the will, you can't make a conditional statement. Like you say, you give something to your wife. You can't say that after she dies, it can go to my children or something like that.
Yes, there are interpretation issues. There are some Supreme Court judgments which have reflected on how a will should be drafted, what can be included or not. You are right there, sir. So there are some statements that you cannot make in a will.
Okay.
So
Thank you.
yes.
Okay, right. If you receive an immovable property in Delhi, do we need to pay stamp duty for registering the property in the name?
If you receive an immovable property in Delhi,
I think
so
the person is referring to a gift.
yes, there is stamp duty on a gift. So your trusts and gifts are treated almost at par in Delhi. It's treated like a conveyance. You will have to pay stamp duty on it, even if it's a free transfer.
And if it's on will?
If it's on a will, there will be no stamp duty.
Thank you.
A very interesting question. If a private family trust has overriding advantage over a will, then why is a trust not being made a mandatory document in heirship or succession?
Sir, uh, you know, it's a golden question. I think the state is waiting for us to leave behind unclaimed assets and is waiting to take advantage of the chaos around it, which is why we started NoGrey, to bring in some order. So it should be made mandatory, actually. This is what we were thinking about today morning, but we are a long way from there. There are many people who are thriving on the chaos in our families. So
Yeah, I think, and also, will has become almost like a common, very, very common word. People talk about it, but somewhere trust is something about which hardly anybody knows. So it's not got into a regular lingo, and that is why people who are drafting official documents and all, it's not in their lingo also.
and so also in the legal fraternity, what we have seen in the last 2 decades is that trust as a area of law was previously managed by a very small community of lawyers, mostly Parsis in Bombay. And they created such a so many boundaries around it and so much of fear around trust law, that very few people had the chance to read through the law and practice in this area, which is why when you initially talked about trusts, it would seem like only the Tatas and the Ambanis and the Rothschild or the your Warren Buffett kinds should be creating trusts. But actually, it is a tool for everyone. It is such a basic document. So this awareness and this practice area of law was not made available to people like us earlier. But now this is what we are trying to do differently. So increasingly, we are seeing there are more companies also doing this, and it will soon become like how you had insurances earlier. It took time for insurances to come and become mainframe. So similarly, trusts will also become very common.
Okay, right. Another interesting question: can a trust be legally challenged?
A trust, anything can be legally challenged. And whether or not that challenge will stand the test of law will depend on how it's drafted and how it's executed. There is nothing that can't be legally challenged.
Okay.
But it will be very difficult to sustain that challenge if you draft it well and you think it through.
Right. Another interesting question from a person who's he's a Nepalese citizen. He's written, you touched on an Indian citizen owning assets in India and abroad. How is a trust for a foreign national who owns asset in his home country and in India created? This person, he's a retired Indian Army officer, and because he's a Nepalese citizen, there is a special arrangement due to which they can own, Indian assets and, of course, Nepalese assets.
Understood, sir. So, you are going to be, in your case, sir, the author of your trust in India, where you can put in your assets in India. There's nothing stopping you from doing that. And you can create that trust. And the only thing is that the Indian Private Trust Act says that a foreign citizen cannot be a trustee on their own trust, but there is a workaround for that. You can be the observer and you can be the beneficiary, and you can find like a consultant or a chartered accountant, or your wealth manager itself can be the trustee. And the trustee's position is actually administrative in most cases. And that ways you can create a trust in India for your India assets, and for your assets in Nepal, you create like the same trust and put your Nepal assets into it and register it in Nepal. But for that, I will have to see what the Nepalese, if there is a separate legislation in Nepal for trusts, and it's possible that the Indian Private Trust Act is also extended to Nepal. So it's interesting, this question coincides with me leaving for Nepal on the 3rd, and I will be meeting some lawyers from Nepal there, and hopefully also the Supreme Court Chief Justice. So I will be able to tell you more about trusts in Nepal perhaps next month. But as far as India is concerned, you can create a private trust here. You can move in your assets into it. For Nepal, if Nepal allows or recognizes the concept of trust law, then you should be able to create a trust there as well. But I would recommend separate trusts for assets in the two countries, and you can have the same instructions in the trust declaration. Just register it separately with the authority there or here. Having said that, I still need to check what the trust law position in Nepal is. So I can check that and tell you in the next month.
There is an adult with mental disability, but the parents have passed away. What should be the way ahead now?
So quite a few things coming to my mind now. One way is now for a relative or a friend to apply for a guardianship certificate for the person with the mental disability. The other way is that not everyone with a mental disability is totally disabled. So there could be phases when the person is able to make some amount of decisions and focus. And then at that point, he or she can work with experts and create a trust for himself. So that is another approach that can be taken. But one of these two things is what will need to be done.
Okay, right. Next one, can a husband and wife properties be made into one trust?
Yes, both can be authors. That's exactly how it is done.
Okay, right. Now a question which was left over from the previous one, but I didn't take it up last time because it was a personal question, but I think we can ask it here because it pertains to Istridhan. Please listen to it carefully. My grandfather gifted a plot to my mother, and my mother and father built a house on it, which was later sold off. With the proceeds, another house was bought where they live, and my brother lives with them. We are only two siblings. Need clarity as to, is this her Istridhan, and can she will it to my brother only, or is it inheritance in which me and my children also have a share?
This will be, in my opinion, treated as self-acquired property that belongs to her, and she can will it to whoever she wants. She has free will in this.
Okay, so it doesn't fall within the purview of Istridhan.
Stridhan is also like something that is for her. So it is like her, you can say it is not like, it doesn't fall, it's not part of your ancestral property framework. It's a gift that was given for her. So in my opinion, Stridhan will not be treated differently. This will be treated as her own property, her self-acquired property.
Okay, okay, okay. So the follow-up question that has come immediately on the chat is, can some clarity be given on, just 1 second. Can some clarity be given on what is, okay, you already answered it, that Stridhan, what is Stridhan? Okay, now we also take up a few questions from the previous webinar which were not answered. And a very important question is, what is the procedure to get a succession certificate?
The procedure to get a succession certificate would be that you will have to make an application to court, and you will have to attach also your legal heirs certificates, and I think there will also be need for attaching the death certificate. So I have here with me Vishesh, who's also a co-founder of NoGrey, and he typically handles the on-field operations for obtaining these certificates. Vishesh, do you have a document ready which details out the documents and the process for applying for a succession certificate, maybe to add more depth to the conversation here than a general answer?
Yes, I'm opening that document, but generally you're right. It is an application made to the court. A public notice is given by the court for a couple of months. Usually it's 30 to 45 days. And after that, they entertain any objections to the succession. So any documents that you have that prove that you're a successor, all the property documents of the properties that you have will have to be given to the court.
Okay.
Yes,
right.
sir.
So will you be putting it here, Mr. Vishesh?
Yes, give me just 1 second.
Yeah, fine. So we'll go on to another question which has just been asked. Can I make a conditional will stating that one sibling will get my self-acquired assets, but he will have to provide certain specified amount to other sibling?
You can write whatever you want in a will, but basically what you're trying to create is a trust when you are writing something like this. And leaving behind such a will actually lead to, I don't know how it will practically help you. You can write whatever you want, but if you want to basically create a trust for the other people, then I would suggest that you create a proper trust and do the thinking through. Because writing such a will is really not going to help the cause entirely, in my opinion.
Pritika, it is generally in the nature of, let's say, the testator is saying that, okay, my one child will get my house and my, let's say, all my mutual funds, but he should provide say 10 lakh rupees to the second child.
Got it. This makes it clearer. So if the distribution is specific and one time, then yes, you can make it like that in the way that Sir has just articulated it. So if you're saying my brother or my nephew will get will get this much, but from this he will have to give an X and Y amount to my children, when they turn this old and this old, that's okay. That's fine. You can do that.
Okay, right. Next question. If there are multiple assets in a will, is a succession certificate required for each asset, or one such certificate is sufficient for distribution of all assets?
In my opinion, all assets, one succession certificate is enough.
Okay. Okay. Uh, if a husband has willed the entire movable and immovable assets to the wife, does the wife have full freedom to further will these assets, or a family agreement oblique settlement would be necessary to execute the wife's will amongst the remaining class 1 heirs?
No, if all of what he has willed is self-acquired property, she can will it to whoever she wants after that.
Okay, so no family agreement, settlement, or anything else is required, because it becomes something like her self-acquired property, if it was a self-acquired
Correct.
property, right?
Yes, correct.
Okay. Property is in the name of father. For property is in the name of father and mother. Uh, I think the English is not very clear. From where to get the succession certificate? How is a will registered?
Property is in the name of both
No,
father and
no. You just leave that out. That question out. This is our next question. From where to get a succession certificate, and how is a will registered?
So you will get a succession certificate from the district court of the area where you are domiciled. Vishesh, would you like to add to that?
Yes, so that's right. It has to be applied to the district court. Sometimes certain powers are given to other authorities as well, so it has to be checked as per the state laws. Yeah, that's it. And here you can see the documents that are required for obtaining a succession certificate, or any additional documents that may be required, which also include documents that are usually required under a legal heir certificate as well.
Okay, right. Can a registered will be changed?
Yes, you can amend your will at any time you want, but then you will have to get that amendment re-registered.
Okay. Generally, Pritika, what I've seen is that there are lots of questions around an executor. So one such question: what is better as an executor? Beneficiary plus organization, or another friend oblique family member plus organization?
Beneficiary plus organization, or friend and organization?
Friend oblique family member plus organization.
Oblique family member. So definitely there should be two. One organization that is trained to actually get the execution work done, and someone from the, like a trusted family friend or family member, can also be a beneficiary actually. There is I mean, in this second leg, you can choose anyone that you believe has the mental faculty to make sure that he or she works with the organization to get it done.
Okay, right. Now, another question. In case of a single child as a beneficiary, is it important to have an executor?
It is important to have an executor.
And what if you don't have, if your will doesn't have an executor mentioned per se?
Then in that case, what happens is that practically in some cases, the court is seen to appoint an administrator. But in other cases, the beneficiary will itself go and appear as executor.
Okay. What happens if the executor or the witnesses pass away and are not available at the time of execution of the will?
So I haven't seen this scenario play out really. So unless some challenges the will at some point, the beneficiaries should be able to get the will executed. But if there is a challenge at some point, then naturally one will have to fight the dispute.
Okay. And this question, I think this should be the last question. Uh, uh, can a husband and wife write a joint will, or should it be separate?
So you can write a joint will, but I have seen many drafting and interpretational issues in joint wills. So we don't recommend joint wills. It is simpler to keep the two affairs separate. Time and again, we've seen, like we've had people come to us with joint wills, and then there are issues with it.
Okay. Can I say that in a joint will, if let's say it's a joint will of husband and wife, and one of them passes away, then the will freezes. Nothing more can be done in it. It has to be executed as it is.
There could be that sort of an interpretational issue also, basis what is written, sir. Yes, thanks for helping me with that. That is a clear example of the issue that arises. One of them.
Yeah, because when people ask us, we tell them not to go in for a joint will at all. One doesn't know about life, and then circumstances change, and the surviving spouse could have a different view of how the distribution should take place, but can't do it because it is one will, and it is then it gets frozen, right?
Yes, sir. Yes, sir.
Okay. One more question which has come in is, if a registered will exists, do we need to apply for succession certificate? This registration of will creates a doubt. If we receive 10 questions about succession planning, then at least 4 of them are, should I register? Should the will be registered? My will is not registered. I'm scared. Those kind of questions. Can you just clarify it once and for all?
Yes. So, as per law, the Indian Registration Act decides what is mandatory to register and what is not. And will as a document, as per the Registration Act, is not compulsorily registrable. It is up to you. What we as practitioners have seen is that if you don't register your will, it raises a lot of questions. So from a practice standpoint, we highly recommend that you register the will, because many banks will say, no, show me a registered will. They will not accept a non-registered will. Many many government offices will insist, show me a registered will. So at that point, it will become very difficult to go and argue with them that, but registration of a will is not mandatory. So when you see how practically the scheme of things in our country play out, it becomes practically very important to register your will. So please register your wills.
The very last question now. The last one after the last question.
Yes, sir.
And can a person who is a beneficiary in a will be also a witness in the same will?
Can a beneficiary also be a witness? I think, Bambi, you had done your research on this one. I do know we did a research on this one. I'm not sure.
Yeah. So the witnesses must be independent witnesses. They should not be beneficiaries. They should not be somebody who's benefiting from the will. So typically we see people, call over a friend or a family friend, a distant relative, even a neighbor, to just come and witness the execution of the will. And the witnesses don't need to know the contents of the will. All they have to do is see you, the author of the will, properly sign the will, and they themselves will sign on the will. And when you're registering the document, this process takes place in front of the registrar. It's recorded formally at the registrar's office. So yeah, your beneficiary, please do not make them witnesses, because that is seen as a red flag. And tomorrow, if the will is being disputed, challenged, it can be used against you and your family, basically. So yeah.
So, Bambi, there is a very valid, concern raised in the chat. As per my understanding, any registered document becomes a public document, and anyone can ask for a copy from the registrar. it means that the will is no more confidential?
So in our experience, sir, the registrars don't give access to wills unless one of the uh, legal heirs comes to them and asks for it and presents a legal heir certificate. Even in those cases, it is very difficult to get a copy of the will out for all practical purposes. So a will, even if it gets registered, it will not be shared with someone who should not be seeing it. But to be honest, in our country, you can pay money and get any document out. So, so if you see it practically, if you're registering something, then the practical chances of someone getting access to that are quite high by paying some money.
Okay, right. And, one more question. I think we'll close taking the questions. Otherwise, we are already past this. And so you have to now give out as to how will you be helping our investors, our attendees of this webinar who have attended all these for such a period of time. How will you help them in through your company?
Thank you, sir. And thank you everyone for attending these webinars and supporting us. So we at NoGrey have a platform that we have built. Bambi will just very quickly share the platform page with everyone. What we have done is that we have gone deep into the concepts of wills and trusts, and we're a team of lawyers that work together, and we have created products for creation of wills and creation of trusts. And we also facilitate services like your registration services, execution services, and other services related to basically your wealth management from a legal side of things. So we have products that we have built, which Bambi will now discuss with you and share with you how you can reach out to us.
So under our will offerings, at the moment, we have two major offerings. There is a light and a premium. In the light version, which is for 15,000 rupees, plus there is an 18% GST added to it. So it comes up to around 17,000, rupees. And here we give you a very legally watertight will form document, which is very easy to use. You can just fill out the information that's required in it by yourself, and our lawyers will have 2 lawyer consultation calls with you. They'll go over the document with you, make any changes that may be required, and they'll help you finalize the wills. Then we'll also help you with the signing of the will. So we'll make sure you reach out to your witnesses. They come and join you on a particular date and time. We'll join you like this over a video call. We'll facilitate the signing between you and your witnesses. We'll take a video recording of it as well, and we'll share it with you. We have a more premium service as well, which is priced at 35,000 rupees plus 18% GST. Here, you don't have to do any filling out on your own. All you have to do is share the asset information and other beneficiary details, executor details that we will need from you to create your complete wills. So you'll simply receive a short checklist. You'll share the information and documents. We'll do the complete drafting end to end. And again, you will have 2 lawyer consultation calls, and we will, of course, assist you with the whole signing process and give you a recording of the signing process as well. We have additional services as well that I'd like to highlight. Since it's a company that provides end-to-end estate planning products and services, we not only help you draft the will, should you want to go ahead and register it, no matter where you're based out of in India, we have agents and lawyers across, so we can help facilitate the registration process as well. And if a home visit is also required from the registrar, that's also something we can help facilitate. Of course, these services come at additional prices. And for something like home visit, that would be more premium. So there will be a higher cost to it. Typically for registration, we've seen it's around 20 to 25,000 rupees. This is if you're able to go to the sub-registrar's office. We also provide executor services. So a lot of you had questions about appointing a primary executor in an organization. So yes, you can also appoint NoGrey as a co-executor in your wills. And this basically means that, whenever your will is being executed in the future at whatever point of time, your primary executor can come and basically they'll have the option to come to NoGrey and take our services to actually execute the will, whether it's obtaining probate, succession certificate, whatever the process is. And that will, again, at that point, we will share the fee and the process with your primary executor. Similarly, for trusts, we help you create your family trust. We also help create business trusts, charitable trusts as well. For a family trust, we have an all-inclusive fee of 3 lakh rupees plus 18% GST. Here we help you within a span of 4 months. We help you create your complete trust document. We help you register this trust document as well, and we help you ascertain if there is any stamp duty aspect to it. If you want to avoid the stamp duty, then we accordingly help you, structure the will and the trust together so that you don't have to pay that stamp duty. So all of this is included in the 3 lakh price point. For business trusts, of course, it depends on, the size of the business and what the trust is all about. So we typically start at a 12 lakh rupees and then assess. If you're interested in setting up a charitable trust, this is also a service that we provide. And again, there's an all-inclusive fee of just 2 lakh rupees. When it comes to trusts, we have a bunch of additional services that we provide. So a lot of the families that have created their family trusts with us, they also like to, assess NoGrey as one of the co-trustees or as one of the observers on the board. And this gives them a lot of peace of mind because they know then that, they have the trusted people that they appoint as trustees, and they have a professional organization which has a team of experts like lawyers, CAs, bankers to overlook the operation of the trust, to do all of the compliance filings. So there is this option as well. And of course, since we have a team of lawyers and we're backed by a law firm, we also provide additionally, we apply dispute resolution support. So if there are any disputes in your family that you would, like us to help you out with, then that's an additional service that we provide as well. So that's on NoGrey's products and services. And I see some of you have already booked your free consults. I'm getting notifications. So I would encourage all of you to please book the free 15-minute consultation call that we have. Here we are happy to speak to you to understand what your concerns and requirements are and to guide you in the right direction of creating a solid will and trust document. And we'll be happy to take it from there.
Also, what I'd like to add is that we're giving a special discount of 10% on all our products and services for the next 3 months to all Hum Fauji customers.
Yeah.
So if you'd like to avail that discount, then I think we can begin with speaking to you on your first free consult of 15 minutes. We also help families which have assets spread across the country. So the team has enough capability to help with any FEMA concerns, any cross-border concerns. So if If you and your friends have any specific questions regarding that, please feel free to reach out to us. Also, we're a very passionate team of lawyers who are working hard to build NoGrey, India's legal service operating system. We don't have a dedicated sales team. We don't intend to have one. So if you did enjoy, this webinar, then we would request you to also request your friends and family to attend webinars that we host almost each week. They can register through our platform. Please tell people about us. We'd like to work with and assist as many families in India and from India. Thank you so much. Thank you, sir. Thank you, Sanjeev.
Just 1 minute. Just 1 minute. See, I hope Bambi and Pritika haven't seen what I've written in the chat. I've behaved like Donald Trump, right? So Donald Trump said that, I negotiated the ceasefire between India and Pakistan. So I have posted there that Hum Fauji has, through the back door, also negotiated an additional discount of rupees 2,000 for our investors and rupees 1,000 for others attending the webinar, for all those who take the will services of NoGrey. I know Bambi and Pritika are shocked, but I have not stopped at that. I have written that for those taking the trusted, that is family living trust, charitable trust, or family business trust, or business trust services, Hum Fauji has also further negotiated an additional discount of rupees 10,000 for our investors. And even for our non-investors attending this webinar, a rupees 5,000 discount, right? So I know I'll get a lot of big bats from both of them, but it is there. And now it is in writing, so there is no going back.
All right, sir. We shall, we agree with you here, and with that, then we will also make an announcement for our friends and family round of fundraise next when everyone is around. So then all of that is saved, can be invested back into NoGrey with rights in the equity of NoGrey. But that's fine, sir. We are okay with the further discounts that you have offered. I think Bambi or Vishesh you can quickly take a snapshot of this understanding.
No, I'll send it to you in big bold letters. No need for this. Okay. So thank you very much. Thanks, everybody. And I'm really so thankful to NoGrey. I won't only take your names, because I know in such conducting 3 webinars at a stretch, it takes a whole company to be working. Really grateful to you. And I'll just reiterate the Fauji connection that the 2 ladies have with the Fauj, that they are Fauji brats, if I may use that word.
Absolutely.
So, thank you very much, everybody, for being there.